will call to order the Planning Commission meeting for the City of Oregon City, November 18th, 2024. Call the roll, please.
Commissioner LaSalle.
Here.
Commissioner West is excused. Commissioner Laws.
Here.
Commissioner Dole.
Here.
Commissioner Schlagenhofer.
Here.
Vice Chair Espy.
Here.
Chair Stoll.
Here. I'll move on to approval of the minutes. Any discussion or motions?
Move to approve the minutes.
Second. All right, motion's been made and seconded. Any discussion? Okay, call the vote, please.
Commissioner LaSalle.
Aye.
Commissioner Dole.
Aye.
Commissioner Schlagenhofer.
Aye.
Commissioner Laws.
Aye.
Vice Chair Espy.
Aye.
Chair Stoll.
Aye. Move on to public comments for items not on the agenda. Do we have anyone online? Doesn't look like it. Nope. All right, straight through to the public hearing. Read the script here. Public hearing for GLUA 24-00026, ZC 24-0002, LEG 24-00003, Oregon City Municipal Code 17.47, Erosion and Sediment Control Text Amendment. Public hearing on a legislative application is scheduled for tonight. Our role is to conduct the public hearing and to make decisions about the matter before us. In making those decisions, we must apply the applicable codes and laws and cannot vary from or change those laws or codes. Legislative actions involve the adoption or amendment of the city's land use regulations, comprehensive plan, maps, inventories, and other policy documents that affect the entire city or large portions of it. Legislative actions which affect land use shall begin with a public hearing before the Planning Commission. A staff report has been prepared for each application and has been made available to the public 7 days before the first public hearing. The staff report identifies the approval criteria that apply to each applicant's proposal. Staff has analyzed the criteria which are contained in the staff report. Upon a recommendation from the Planning Commission on a legislative action, the City Commission shall hold at least one public hearing on the proposal. Any interested person may provide written or oral testimony on the proposal at or prior to the hearing. At the conclusion of the hearing, the City Commission may adopt, modify, or reject the legislative proposal, or it may remand the matter to the Planning Commission for further consideration. If the decision is to adopt at least some form of the proposal, and thereby amend the city's land use regulations, comprehensive plan, official zoning maps, or component of any of those documents, the City Commission decision shall be enacted as an ordinance. Public testimony will be called on in the order it was requested. If you wish to testify in person, please fill out a speaker card available at the back of the room. If you wish to testify virtually, you will be called either from a request to speak emailed to city staff at planning@orcity.org in advance of this meeting, or by raising your virtual or physical hand when I ask if there are others in the audience who would like to participate. For the public record, please begin all testimony stating your name and city of residence. If you would like to receive a copy of the notice of decision, please state your mailing address or email address. Testimony and evidence should be directed toward the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain how and why you believe they apply to the application under consideration. Any person may submit written material while the public record is open on each application. Any written material received by the city staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing may be presented to the city staff in order to become part of the public record. If a person intends for PowerPoint presentations, reports, pictures, or other exhibits used in their oral testimony to be placed in the record, copies must be submitted to the city staff while the record is open. If they are not given to staff, they will not be included in the record. Any person wishing a continuance to present additional evidence and testimony or to keep the record open to respond to new evidence must make that request before the public testimony portion of the initial hearing is closed. I'll now ask all the commissioners for if they have any conflicts of interest. I'll start with Commissioner LaSalle.
No conflict of interest or bias.
No conflicts of interest. No conflicts.
No conflicts.
No conflicts. All right, I have no conflicts of interest. We'll start off with the staff report.
Thank you. So I'm going to just present the first part of this, and then I will turn it over to Marcos Kubo from our Public Works Department, who's the applicant. Okay, so tonight we're here for the first public hearing for this legislative amendment. As you heard Chair Stoll just read the disclosures for. And yeah, and we can go to the next one when you're ready. So it's a type 4, it's a type 4 application and a public hearing process. So the way that these legislative amendments work is the first hearing starts with your body and you make a recommendation to City Commission, and then it will move on to City Commission. As you already went through, there's no need for the ex parte disclosures, but you did talk about conflicts of interest. And typically we have updated public comment matrix, but I don't believe there were any public comments submitted on this particular item. So the proposal is to amend the language in Chapter 1747, which right now addresses erosion control. And this is necessary to comply with Oregon's Department of Environmental Quality, otherwise known as DEQ, for our MS4 permit, which stands for something that I will let Marcos tell you about, but I think it's storm, sewer, separated system, something like that. Maybe not in that order, but. So there are 4 S's. That's why it's a MS, for the M is municipal. Anyway, that's why it's a MS4 permit. It just sounds better to say it that way. So right now, what's not currently addressed in the code is construction site runoff. And so that's what will get kind of amended is into the language, is that specific language to deal with construction debris and erosion control. There aren't any other regulatory changes to erosion control or the way that we do sediment control. It's mostly just to manage this construction site runoff. So can you go to the next one? So the criteria for approval in a legislative amendment, which is what this is, are mostly if it complies with our comprehensive plan, or our OC 2040 plan. So we went through, and what you have in your packet are the analysis and findings that go through and analyze if this meets those criteria. And then we'll look at the applicable goals and policies within the comprehensive plan. And then the second part is the state land use goals that the Department of Land Conservation and Development administers. And so we'll go through, and we really only make findings for the goals that are applicable. And so those are the basic findings that you have in your staff report. So if you have questions on those, we can go through that when it's time for questions. And then, so your options tonight are to either approve the proposal as it's proposed, or excuse me, your option is to make a recommendation of approval as proposed, or recommend approval with modifications, or give us some direction for what you might want to see that's different. I'll also just add that we're doing this to comply with DEQ, so I don't know how much room there is for variation, but I'm happy to take your questions and comments and feedback. And so that's all I have from my point. And Chair Stoll, if you like, I can turn it over to the applicant, or if you'd like to.
Yeah, please.
Okay. All right, so I'll introduce, this is Marcos Kubo, and he's from our Public Works Department. And remind me your title.
Water Quality Coordinator for Stormwater.
Okay, he's our Water Quality Coordinator, and he will go through more information on these amendments, so thank you.
Thank you for your time, Commissioners. Good evening. So I'll try not to repeat everything that Aquila said, because she pretty much nailed it. This presentation is it satisfies two requirements of the permit. I'm required to present to the Planning Commission, and I'm also here to amend or hopefully get you to approve the amendment of this code. And so I'm going to briefly tell you what we're amending, why we're amending it, and how this impacts the city.
Is it not working? We can forward the slides too.
Yeah, if you could just advance, please. So we are amending Chapter 4.7 with additional terms, as Aquila said. Pollutants beyond sediment and stormwater runoff. It also includes basically any kind of waste that would leave the construction site. We already inspect construction sites for best management practices, including waste management controls. These added terms just put it in codified writing. This change in language, advance please. This change in language is required by our stormwater permit, and adding construction waste to the language covers any pollution that leaves the site. We already enforce this during construction, as I said before, but the Environmental Protection Agency, EPA, and Oregon Department of Environmental Quality, DEQ, want it in writing for legal enforcement to hold contractors responsible for any type of pollution beyond sediment and stormwater runoff. Advance, please. These changes don't affect how we do business or slow down development because we already require contractors to manage their waste. Public work staff have been briefed on this amendment and will continue to inspect construction sites per their standards of practice. And that's all I got. Thank you for allowing me to present to you all while I facilitate required amendments. I'm happy to answer any questions you may have about the amendment or stormwater, surface water related questions.
Commissioner Laws?
So what is the procedure typically if there's complaint, if arise by like a resident, if there's like debris or sediment or they have concerns, what's that process exactly like? I'm asking not just as a resident myself, but just for a public comment.
So basically we have 3 levels of escalating enforcement, and it's been that way before we have started this amendment. There's the notice of non-compliance. So basically we have an inspection form, we tell them what's wrong, we tell them how to fix it, and then if they don't fix it, we give them a stop work order. So they are required to stop work, and if they still don't comply, then we add on civil penalties or violations, or for the violations. And so that would include fines and, mostly just fines and legal constraints.
And just curiosity, is there times when the city doesn't enforce and then they rely on DEQ to enforce, or is that complementary?
Since I've been here for the past 2 years, I am unaware of any time DEQ has had to get involved. There was one issue I had with an industrial facility that was not complying with me, and DEQ did a surprise inspection for them. But as far as construction, we've had pretty good luck with our contractors, and they've either complied after the notice or have maintained satisfactory work the entire way through. We had a few stop work orders last year, I believe, but other than that, they've managed to keep up with business.
Thank you.
All right, any other questions for applicant or staff? Yeah, go ahead, Dirk.
Okay, so we're pretty much doing these to become DEQ compliant or to keep up with DEQ compliance. Okay, in other parts of our code, this has come up a few times, and I see it's in here too, like for example, 17.47.100, section B. I'm just gonna pick a random one. In cases where significant erosion is occurring, the manager may require the owner or his or her designated representative to install immediately. Okay. The question is, this term comes up a lot, the manager, but is it the manager of Public Works? Is it the city manager? Who's the manager? Who are we pointing out? Is it time to clarify that a little bit? Be a good opportunity to do that.
That's a good question.
And the manager pops up all over the place.
That's true. Yeah, it may be a good idea to point out that it's the...
Normally, whose job is that? If someone was to do a stop order, or, I mean, would that be someone within Public Works?
I think that's pretty common in code
Yes,
language.
so
Okay.
typically in...
The manager and in parentheses or designee, and it's implied that it would be the designee of the city manager.
Yeah, typically in code language where it says manager, and I'm seeing what you're looking at, Dirk, and it's not consistently capitalized either, so it makes you wonder.
Yeah.
But typically it's supposed to be the city manager, and then that person designates the person in charge. So it kind of goes,
Okay.
in this case, city manager, public works director, and then maybe to Marcos. I'm not sure if you're the one that starts enforcement.
John Burrell is typically the one who manages all the construction site inspections. We also have Jake, I'm blanking on his last name, but currently we have 2 erosion control inspectors at Public Works, so that would be the first line of defense, and then there's the director and the city manager.
Yeah, and in definitions of Chapter 17 says manager means the city manager or the city manager's designated representative.
Okay. Does this always go to the city manager?
Everything is the city manager's responsibility until delegated. That's my understanding, basically.
Okay.
Yeah.
So he's always in the loop.
Well, I don't know if he's always
Well,
in the loop, but he's always in charge.
not in day-to-day operations.
Okay,
but
I was
just
wondering.
the way
His phone would be going off the hook if he was really, contacted for every one of these.
That's right, his phone would be ringing off the hook, yeah. So it's just, I think it's kind of a catch-all way to write code, and that way, let's say that for some reason erosion control moved from Public Works to community development. So now it becomes, my responsibility instead of Dana Webb's responsibility.
Yeah.
And then we don't have to go change the code and find all the little places where we've said,
Okay.
Public Works.
So that term just makes, regardless of who it is in that situation, that term works. No need to change it. Okay? All right, I'm happy with that. Thank you.
Okay, any other questions? Commissioner Laws, go ahead.
So I agree with, on a few concerns there, because one thing that has come up in being involved just in general with the neighborhood association, since this isn't, is a lot of the neighborhoods in general talk about, obviously the code ends with the city manager on most things. What kind of concerns me with all of it is the checks and balances, because if you have a land use application, the bottom line is the city manager also runs city staff and also runs the city attorney. So is there some type of check and balances? That would obviously be the commission. Is there any other way of checks and balances? Because ultimately it falls on the city manager, and the city manager can make that decision unless someone else is delegated to. Is there any checks and balances with that? Because obviously the city manager, like I said, he's in charge of the city staff. He basically, manages the city attorneys. is there any types of, is the commission ever considering to doing something different in terms of checks and balances? Because ultimately, it really gives power to the city manager to make all the decisions at the end on land use.
So the city manager has, in our case, 5 different bosses that he reports to. In other cities, sometimes they have 7 bosses, or sometimes they have 3, depends on the makeup of the council or the commission. And we are here to carry out their direction and their policy. So that is part of the checks and balance. The other part is that the directors push back, and we all kind of push back on each other when we think that, you know, that there needs to be more opinions considered, so. But I wonder when the last time is that our city manager got involved in maybe an erosion control code enforcement case. I mean, sometimes, you know, they rise up to that level, but that's usually where the checks and balance comes in, is with the city commission.
On Holmes Lane right now, there's a lot of sediment at the edge of Singer Creek, and there was a lot of sediment issues with that and erosion, because we're looking at the sewage lines being updated, and obviously it's an improvement on the runoff that goes down to the Willamette River. But it'd be interesting, I'm glad that's happening. Obviously it's very expensive, but obviously with the land use development, the balance would be is, you know, you do have SDC fees, but what balance is that the developer's actually paying for, depending on how big a size that it's putting a burden on the city. And obviously there's some grant money can be applied for and other things, but I mean, some of it's unknown, obviously, right? Who's coming in, how many people are going to be per unit, but it's just an interesting, you know, it's a great, you know, as a planning commissioner, what the balance is of that. So I'm just, you know, all we can do is try to the best we can, but it'd be nice to have, you know, because some of us obviously aren't engineers, so we're really relying on that information to be concrete. So thank you.
Okay, any other questions? Yeah, go ahead.
Okay, yeah. So Commissioner Laws brought up some good things, and I'm wondering, if somebody had an objection to the city manager's opinion, could they escalate that higher? Could they ask the city commission to intervene and say, hey, I think the city manager is seeing this wrong? I mean, is there any way they can go with it if they disagree?
So I guess it depends on the situation, and in a minute I may ask if Mr. Kabizman has a different opinion on this. But let's say that we're talking about an actual land use decision, right? Like a type 2 decision that's staff level. So somewhere in the code, it has designated city manager to make this decision, which the city manager does not review land use at this point in time. He's delegated that. And so the process, if somebody doesn't agree with that type 2, is to appeal it, right? They could appeal it, and that goes straight to the city commission. It skips your body. Same with like a type 3, you know, type 3 and type 4 that come before you can be appealed to city commission as well. So I think it depends on the situation. But I guess I'd have to maybe understand like a scenario a little bit better.
All right, how about this scenario? Someone's got erosion control barriers up, but then we've got a unprecedented rainfall and a bunch of mudslides down a hill. It goes into someone else's backyard, and then the place that it goes to is they want to find a developer for not putting up adequate erosion control. And the city manager agrees and says, okay, let's impose some fines. But then the person doing the developing thinks, this was act of God, this wasn't my fault. Can he disagree with the city manager and say, I don't owe you anything, this was not my fault? Can they bring an engineer in? Or that's where I'm asking, is that the final say? How can it disagree with a code enforcement ruling?
Sure, I mean, we can get into negotiations with with an applicant and they can provide other evidence. I think there is a way to go around that decision or to appeal it, if you will. So thanks, Bill, for jumping on. I don't know if you have any insight into that scenario.
I do think you're sort of focusing on the specifics is helpful in terms of how you do it, because there are a variety of different things. To the extent there's a decision that's made, then yeah, there's type 2, 3, those are all appealable within the city. To the extent there's a code enforcement process, there's different aspects from, sort of the applicant. Let's say the city manager, following through on Commissioner Schlagenhofer's example, city manager says we're going to fine you X amount. Typically, in most code enforcement situations, there's some discussion, exchange of information, and that may well end up resolving the matter. Alternatively, to the extent the applicant or developer says, no, I'm not going to pay it, where that would end up going would be to municipal court for code enforcement, where they can make those arguments to the judge. And all municipal court matters can also be appealed directly to the circuit court. So you're always going to get the ability, as far as if you're fined, to challenge it further at court.
Okay, very good, thank you.
And I guess I do want to point out one other thing. When you're talking about the city manager's roles and responsibilities, Section 20, Oregon City, like probably, I believe the majority of cities in the state are considered what's known as a strong manager city. If you look at our charter, Section 21 provides the powers and duties of the city manager, and Section C2 says that he shall see that all ordinances are enforced and that the provisions of all franchises, leases, contracts, permits, privileges granted by the city are observed. That's why the default provision is to have the city manager being the person doing the enforcement, and it defaults to them. The commission can delegate elsewhere, but that's sort of what drives it, is the nature of the city structure, which is, as I said, common throughout the state. You've got a strong city manager, and to the extent people are not happy with the way the manager is performing their job, typically the way to approach that is to bringing it to the city governing body, the city commission in this case.
Okay, thank you.
All right. You have a question, comment?
No question.
Okay.
I was going to move to make a motion.
All right. Well, thank you for coming up, and any further discussion or motion?
No discussion on my end. I'd like to make a motion to approve LEG 24-03 as proposed.
I'll second that.
Okay. Excuse me, motion's been made and seconded. Any discussion? All right, call the vote, please.
Commissioner LaSalle?
Aye.
Commissioner Laws?
Aye.
Commissioner Dole?
Aye.
Commissioner Schlagenhofer?
Aye.
Vice Chair Espy?
Aye.
Chair Stoll?
Aye. All right, move on to communications.
All right, thank you. So, good news and bad news, which I don't know what you'd like first, but the good news is we don't have a meeting next week. So our meeting next week is canceled, mostly just because the item that I thought was going to be presented is not ready yet. It wasn't. It's not. The application isn't even complete. So we've got a little ways to go. So we're canceling that one. But we do have. This is the bad news. We do have a meeting December 9th, which I didn't have on the calendar. And that is for another legislative amendment that's a little bit fast-tracked. It's taken staff, and frankly, staff throughout the state, to a little while to come up quickly to speed on this requirement. So we will be bringing to you some amendments to our floodplain chapter. This first amendment is really just going to add some brief language that requires development in the floodplain to go through something called a permit by permit process. And then we are going to go back and update our floodplain code and bring a new ordinance to you. So just to kind of give you a little bit of background, and I think Commissioner Espy's gone through this, so he might have more or additional information, but let's see. I'm going to start pretty far back here. So this goes all the way back to 2009 when there was an environmental group who I think this is a detail, and we'll get the detail right when we bring it to you for review, but I believe the environmental group sued FEMA and told FEMA that they were supposed to be consulting with this group called NMFS, which stands for National Marine Board Fisheries, something like that. And they help execute and protect endangered species. So they execute the Endangered Species Act. Let me not get that part wrong. They execute the act and protect the species. And FEMA was supposed to be consulting with them when they reviewed floodplain ordinances and cities who were in the floodplain and participate in the National Flood Insurance Program. So our city does that. We participate in that program, and it helps reduce flood insurance rates for our property owners within the floodplain. So fast forward from 2009 to, I think it was 2016, the National NMFS, Marine Board Fisheries, and FEMA kind of came to a settlement where they agreed on reasonable and prudent measures. I don't know what that means either. So fast forward a few more years, and the way that FEMA now has to implement this is by requiring any development in the floodplain to prove that they are not impacting the habitat of endangered species, and that the development within the floodplain will have a no net loss effect. And so then cities found this out around July, although it didn't become clear to a lot of us until maybe September, October, that we had until December 1st to adopt something. And I guess there was not, I know we're on YouTube and we're being recorded, so I'm trying to say this appropriately. I guess there was not a recognition of what it takes to adopt a land use ordinance in Oregon. And this only applies to Oregon, this compliance measure. So now what we are required to do, it's called a pre-implementation compliance measure, PICM. And we have three choices. One choice is to say no development can happen in the floodplain, which sounds like a takings, or we can adopt the model ordinance, or we can do this permit by permit process. And so we're going to do a hybrid where we incorporate some language that says, applicant, you're in the floodplain, you need to go through this permit by permit process. And so all you're going to see in December is kind of a few lines of code. And then that buys us time to actually update the ordinance according to their model ordinance and get that right. We feel comfortable with this because we don't foresee a lot of development in the floodplain. We have to have the model ordinance done it has to be in effect by July of 25. So between January and July, we don't foresee a lot of development in the floodplain, very little. So we think this is going to be an okay way to proceed. Let's see, what else was I going to tell you about that? So anyway, so we're bringing this ordinance to you December 9th, and then we'll move through. So we're going to be late, but we're doing what we can. And I think what we've heard is that as long as we keep FEMA updated with our progress, then we will be okay and not be removed from the flood insurance program. And so then we'll take it to City Commission in December and January. Oh, this is what I was going to tell you. So it's called a PICM, or pre-implementation compliance measure, because they're still going through the environmental assessment, the EIS environment. Where's the I in there? Anyway, they're still going through an EIS, environmental impact statement, and that will be done, they think it's sometime in 26. And that may mean that we have to then update our code one more time. So that's why it's pre-implementation compliance, because we're doing this compliance ahead of when the actual EIS will be done. And that's what we're bringing to you in December.
All right. Any other communications? All right. We are adjourned.